Okay, hello everyone, and welcome to one more series powered by Adraas, which is a real-time environment for dispute resolution. We have with us our speaker from Nepal this time, and that's Mr. Nabin Bhandari. And incidentally, I met Mr. Nabin in a couple of conferences in Delhi, and we discussed a bit about India and Nepal. And so he said today's topic would be something related to that public policy. So, how does public policy come into play when we go into arbitration? Obviously, we all know that as per the Indian Arbitration and Conciliation Act, public policy is one of the grounds or a defense against which an award can be set aside. And Mr. Nabin is from Nepal, so I'm going to see how his experience is in relation to that. Now, very quickly, for a lot of speakers, I say that public policy is not rigid. It varies from place to place. It could vary even within the city, within the country, from your family to your next door. It could vary between you and your colleague. So, public policy is so fluid. So, how can we tame it? In fact, one of the earliest things, I think, by Judge Barrow in 1750s, 1770 something, he said that public policy is like a wild horse, which can take you somewhere which the rider doesn't know. It's an unruly horse. And then Lord Denning, almost 150 years later, said that with a sturdy person in the stead, he can actually tame the horse. So that is how far back this public policy has gone. In fact, I think the earliest document was 1400s related to public policy that I came across. 1400. I'm talking about what, 600 years ago? So it's a never-ending topic, very vast. I don't want to be talking, I want to listen to Nabin about his experience. So quickly, Nabin, for our viewers' understanding and even for my own sake, I think you got your law degree and you've been practicing in Nepal for the most part.
Yes, yes.
Do you also practice in India?
No, definitely not. My practice is based in Nepal itself.
Okay, but have you come across any issues that are, let's say, international disputes between India, Nepal, or something else?
Yes, yes, we have got like on few cases we've been, but there is some part that has been an issue as well. So I'll describe it later.
Hmm.
So yeah. We look after some, in arbitration dispute, any one of the parties in Indian party, Nepali party, and all. Yes, we have gone through such cases.
Okay, so let me dive directly straight into that.
Okay.
First, let's forget all other countries and think only about Nepal and say that can you help us understand how public policy is regarded in Nepal?
Mhm. So yeah, in context of Nepal, we have Arbitration Act 1999. So this section 34 states that on the two ground you can foreign judgment cannot be enforced. One ground is public policy, another is like if the subject matter of dispute is not arbitrable. I mean, so such dispute is not cannot be looked to arbitration, and on such case, court has the right to not to enforce this award. So yeah, we have seen since public policy itself is a vague term, as you have rightly said. It's like it's unruly hurts. Like for public policy, it's unruly hurts. It's like, and you cannot know like where that horse will take into. Like that's one of the famous quote in terms of public policy, right? So yeah, we do have such provisions. It has been exercised by the court as well, and yeah, quite. But the concern is like there is no exact definitions how the public policy should be defined. That's the main concern.
Now, have you come across anything in Nepal which
Hmm.
was acceptable a few years ago or which was not acceptable a few years ago? And
Hmm.
now the courts have taken the complete opposite stand.
So
That is
not
what public policy is.
yeah, not exactly like such definition has been made yet, right? But there are grounds. The court has simply said on the ground of public policy, this award is not enforced. That's the situation. But my concern as a whole is like this is not a problem of Nepal only, right? This is a problem of most of the jurisdictions. Like since we don't have any soft law that defines the public policy, first concern. Second, neither the New York Convention 1958 that defines that convention is for particularly for enforcement of arbitration or what, and that also doesn't define what public policy is. Neither the ancestral law. So the problem is within different jurisdictions, right? Not only for Nepal as well. But the good thing is for India is in 2017, there was one case, like the court has given three element. It was in 2017, right? A case that has given quite Renaissance Energy Company Limited. It is a case that has given three criteria public policy, which is quite adorable case for me.
Which,
So
what's the
I relate
judgment's
to this.
name?
I need to cite. It's like Renaissance. Just one moment. I need to just look into it.
Renu
Right.
Sagar.
Yeah. The case was in 2017, right? Which has given a three grounds of, you know, uh, grounds. I have just picked up that point. I had studied this case during my LLM course.
Hmm.
And to address that particular case, right? It's 2017 case judgment. It has defined. So it was an energy disputes, right? And exactly, okay. The case is like General Electric Co. versus Reno Sagar Power Company. It's energy dispute case,
We call
and
it just the Renu Sagar case.
yeah, Reno Sagar case. Yeah,
Yes.
I read this case during my LLM studies, during my arbitration course, and yeah, it is quite positive aspect as well. From positive, like at least they have given some, despite itself, there are three vague issues that they have defined again, but at least the local court has tried to, narrow down the scope of public policy. That is one good case that I was impressed of, like on this matter. Mhm.
Can
You
can
know,
you elaborate on those 3 points? I'm
yeah, 3 points
curious.
like one is like violation of fundamental policy of Indian law, the first
Hmm.
point. And second was like award was against the interest of India, the second aspect. And third is award was against the justice or morality.
Morality, yes.
Again, I am saying this, the term justice, the term morality is itself a vague. Again, I am saying is violation of fundamental policy. The term fundamental policy is itself a vague word. And against the interest of India is again a vague word. Despite of this, court has at least taken a good initiative to recognize to define the public policy at least.
Can you tell me of any other jurisdiction where you have come across this public policy which was considered to be different from Nepal?
Mhm.
Something more specific?
Not exactly. That's the problem that we need to solve, right? The arbitration community should now work on.
Hmm.
So how can we address? See, it's not about a national, like, see, if a foreign arbitration judgment is given, okay, that judgment will taken into the local court for the enforcement, right? When you go to China and Russia, right, they have such a wider scope. The political elements comes to enforce the arbitration judgment, right, in comparison to other jurisdictions. Now, this has been a problem. So my suggestions on this part would be, now the international arbitration community should develop the soft law or should incorporate the same in the New York Convention. I don't know whether it's possible to amend the New York Convention or not, right? Or at least a definition has to come up so that this public policy could not be misused by the court through the political interest or any interest. So that is necessary because see, ultimately, the arbitration is about enforcement. Okay, we are talking about arbitrations, and if the problems come on enforcement on this vague ground, then we need to be concerned on this part, like what is public policy definition has to be given.
Well, let me say that you have opened up a can of worms. It's such a big topic. Let's pick one example.
Mhm.
Let's say a particular company has spent 10,000 crore rupees or $1 million or $100 million, whatever you want to pick.
Mhm.
and they have spent all that money on their research and development to try to find a vaccine for COVID
Mhm.
or a medicine for COVID, right? And when they entered into this research domain, there was no guarantee that they would be able to achieve the result.
Mhm. Mhm.
So it was a $100 million risk which the company took.
Mhm. Mhm.
And then they came out with this vaccine, and the vaccine has passed through all the trials, and it has been proven to be 100% effective against COVID.
Mhm.
But for the to manufacture the product, it takes only, let's say, 100 rupees. But because this company has spent 10,000 crores in this
Mhm.
vaccine, they want to also make some money out of that. So they are charging and making the 10,000 rupees,
Mhm.
which is not financially viable for most of the people. So, as a public policy, I'm not talking about arbitration, but as public policy, will the government now step in and say, we want to make that research public,
Mhm.
and you, single company, you suffer, but the rest of the country is going to benefit?
Yeah.
Is that a correct thing? I'm not asking you for an answer. All I'm saying is that that is the kind of philosophical question we'll be faced when we are dealing with public policy.
Mhm.
What if that company has been unsuccessful? They would have
Mhm.
lost that $100 million.
Mhm.
But if you do this, you are going to kill capitalism.
Mhm. Mhm.
But again, what about the social interest? How do you balance the social interest, the greater good of the public versus benefit of one company? So this is a ever never-ending debate, keeps on raging for ages together. As of now, there's been no answer.
Mhm.
Your answer could be very different from my answer, and it could vary even after 10 years. I may give a different answer.
Yeah, exactly. But again, I'm saying that public policy that impacts, like as you said, differs from community to community within the nation itself. The social, religious, cultural matters also comes in between, right? So yeah, social interest matter comes, political
Hmm.
interest matters comes in between. So yeah, it's quite a vague topic, but we need to at least, my concern would be at least make a standard, at least we define some criteria, okay, so that this could not be missed. The concern is you do for the good purpose, no problem, right? No problem with that law, okay? But if that is misused with a bad intention, right,
Hmm.
then that is a problem. So still, my concern would be we need to address this. The whole international arbitration community should at least specify a criteria, right? And another aspect, to add on this, mm, the problem was now a few jurisdiction has developed some, I mean to say, few arbitration experts have suggested that, you know, we need to see this not from the domestic perspectives to one transactional perspectives. That means, some standard has to be described, right? While giving the interpretations or while giving the judgment from the local court, because this comes ultimately to the local court, right? Because whether you get decision from international arbitration institutions or ad hoc tribunal, the question that the case will be for the enforcement will go through the local court of that particular jurisdiction, and the local court should look from two angles, transaction angles, that is specifying the standard of public policy first. Second, let's suppose if that is not, at least look through international perspective, okay. At least what is the practice of different jurisdictions and all. So that should be done. That is the argument presented by few experts on arbitration, so which is quite adorable, and I support their argument. That is necessary.
That is the problem. See, one of the things you're talking about, which I may also explain for our readers, at least the viewers' benefit, is public policy can be defined into three ways. One is the national level, which is much more wider, and then you come to the international level, which becomes a little bit narrower, and then another come to the transnational level. Transnational public policy is the most narrowest, but that is something which all the nations would accept. For example, terrorism, people would say that's a strict no. And let's say killing somebody on the name of religion or genocide, something like that. Those are things which most people agree. But this is where things starts getting tricky. When we say transnational, what if there is a country which has legalized bribery? Bribing somebody is legal as long as there are certain rules on how to even bribe somebody.
Mhm.
You can take an official bribe of 10%, but not more than that. But bribing somebody and getting an award in your favor is wrong in India.
Mhm.
So how do we deal with that kind of, because that country says in our country, for our social economic situations, it's okay to bribe.
Mhm. Mhm.
So that's the kind of answer which there is no answer.
I believe I could propose a solution for this.
Go
Like,
ahead.
this comes like this came in my mind, right? So like as like a New York conventions or any part of that convention, you can amend that convention as well. There is a provision of reservations, right? You define the standards. Okay, define the standards, right? As per the like you define that standard, and the country can keep a reservations. Okay, on this matter, I'll reserve on this matter because my law allows so. So at least some framework could come over, and people know. Okay, this country has reservation on this. They may not. Okay, that is particularly defined. Okay, they may not entertain this disputes, right? Or they may not entertain this arbitration award, right? So that would be my suggestions on that part, you know.
So you're saying, for the time being, come out with a definition of public policy for each country and list it all in one massive document. So if I'm having a case with you against you, let's say,
Mhm.
and this is an international dispute between India and Nepal, then we both will look at those two chapters, what are not accepted in Nepal, what are not accepted in India, and we say these are the things which we should not allow in this arbitration. Something like that, yeah, it's interesting how we prepare a common checklist. But how long will that be valid? Because if we come out with a public policy today, 5 years later, something happens, or the political powers change, or there's another outbreak like COVID or something happens, there's an earthquake, will the public policy change then? Or should we say that this public policy will shall be valid for 10 years, come no matter what? But then after that, we once again revisit the public policy. It's a debate, nice to discuss, but I don't know. As you said, probably that we need to start somewhere, and research level, at least there is some common convergence
Mhm.
on for legal luminaries in the literature front. But when it comes to practice, as of now, I have not yet seen that kind of there's lot more divergence than the convergence happening there.
Mhm.
So, all right, that was very interesting, and I have taken more time than I intended, but as this is one of the topics which I can keep on talking and I can keep on listening. There's no end to it. But well, as a concluding remark,
Mhm.
what should
Mhm.
we call this book that you would be publishing on public policy? Public policy by Nabin Bhandari.
Yeah, for my conclusion on the whole this conversation would be, uh, at least a standard has to be developed from transnational perspectives, and that standard has to be adopted by the domestic law. During the adoptions, like let's suppose we have some international convention on this, that's like a New York convention, or you can amend that. Okay, fine. So you can keep a reservations on that first. The country can keep reservations as per your domestic law first. Second, again on that matter, again based on the reservation, they can amend their domestic law on this matter. If we had some standard developed, they can amend as per the domestic. They could reflect that reservations and all in the domestic law. So yeah, and again you said the law change as per change in time. So we should revisit it again and again. So yeah, the time will teach us how those standard has to be changed as per the change in time. Yeah.
How about this time I give a concluding remark?
Mm.
And I say, let all the advocates
Mhm.
shall mandatorily learn horse riding.
Yeah.
Horse riding.
Okay. For that also, the riding as well. So they need to just have standard how to take a ride and all. So again, my point would be few standard. So yeah, like or very yeah that statement given through a few uh, arbitration even judge. I believe this those are like public policies unruly hers that can take you to like anywhere that the hearts want to. So yeah, so quite a touching line for the public policy aspect, and I admire that quote. Yeah.
All right. That's great. And it was a lively discussion. I thank you for your time. And I hope we'll get a chance to meet once again soon, one more conference. This time, I hope it will be Nepal.
Mhm.
Uh,
Yeah, we wish to do that. Yeah, yeah,
that will
please.
be great if I can come to Nepal and we can meet over there. All right.
Yeah, and also we'll be visiting on February 22nd to 24, 24 to 26. For that, so I believe we'll meet soon at Delhi.
Hopefully, we'll see that. Yes.
Yeah.
Thank you.
Pleasure speaking with you, right,
Pleasure
Reddy?
talking to you too.